Here's 3 things to tell your lawyer after you've been arrested for DUI in British Columbia. Number 1, did you get a 90-day driving prohibition and a 30-day car impound, or do you have a court date? There are 2 different types of DUI that you can get in British Columbia, Canada. And so if you get the 90-day DUI with the 30-day impound, that can be something that requires very short timelines to dispute and a very specific process to successfully dispute it, whereas the court date is typically going to be set a couple months down the road. You're innocent until proven guilty. There's a longer process to resolve the matter, and so the actions that are required are less urgent on the front end than they are with the 90-day prohibition for impaired driving. So the number 1 thing that you should tell them is what type of DUI you have. And the way to know the difference is, was your car impounded for 30 days or was it not? If it wasn't impounded for 30 days, then you know that you're likely facing the criminal charge and the court date. You can still get a 90-day prohibition with that, but the car impound is what's going to tell you the difference. The number 2 thing that you should tell your lawyer after your DUI arrest is whether you have any evidence or witnesses that can help support your innocence. For example, if you were arrested for DUI after failing to provide a sample into a breathalyzer, do you have a medical condition? Can you get medical records? If you don't think that you drank enough to be over the limit, who was with you? Who can talk about what you had to drink and when? Tell them that information. Write it all down. Write "to my lawyer" at the top of the page and make sure that you have good notes about all of that, because that's the type of information that might ultimately be important for you to get down the road. And if you start gathering it and thinking about it at the close in time to when the incident took place, it's more likely going to be available to you when you need it, either in disputing your prohibition or ultimately in potentially calling evidence in court. And the third thing that you should tell your lawyer after your DUI arrest is a truthful response to anything they ask. There are some things your lawyer might not want to know. We might not want to know right away, or maybe ever, how much you had to drink or where you were or what you were doing. But in lots of circumstances, we might not want to know that. What we don't want to find out down the road is surprises. Your lawyer does not want to be, lawyers hate surprises. We love predictability. We love knowing what's going to happen, especially defense lawyers, because the prosecution is obligated to disclose their whole case to us. So we're not used to getting surprised except by our clients. And that's only going to hurt your case. Don't lie to your lawyer. If things are bad and your lawyer's asking you information about it and the truth is bad or you think it looks bad for you, don't lie. Don't lie. Just tell us, because then we know what we're dealing with and we can advise you on what the likely outcome might be. We can advise you on where things hurt your case. And also, a lot of DUI law is kind of counterintuitive. So things that you might initially think are hurtful to your case may actually ultimately be helpful, which is why your lawyer's probably asking you about it, to determine whether there's helpful information that may come out of circumstances that otherwise seem bad. So just tell your lawyer the truth. Your lawyer can never be compelled as a witness against you. They can never tell anyone what you told them about what happened during your DUI. So tell them the truth. Don't hold anything back. Don't let your lawyer be surprised.